Deputy Speaker, it's a particular pleasure to follow the Right Honourable Member for Aberavon, whose committee, I think, produced the best guide to the government's proposals and indeed the best guide to its weaknesses and its threats to our current civil liberties. In recent months, the Prime Minister has quite rightly received serious plaudits for the way he handled the apology for the Bloody Sunday massacre and the Finucane murder. He did so with great openness and sensitivity. Both of those inquiries exposed unlawful killing, both either directly or indirectly, by agents of the state and subsequent cover-ups. Thankfully, this sort of thing is extraordinarily rare in the United Kingdom. And one of the reasons it's rare is because such things are exposed and deterred by an open and transparent system of justice. The whole system of justice, the criminal judicial system, the inquest system, and the civil court system. Now, what part of this bill does today is to create the power to take parts of that civil judicial system, not just out of the public domain, that already happens in some ways, but completely out of the normal judicial testing procedure. So evidence can be presented by the government which the other side cannot see, and even their defence lawyers cannot see. That evidence cannot be tested and therefore may be wholly wrong and misleading. And this undermines the very thing that makes our judicial system work. I'll give way there. Yep.
What role does the honourable gentleman imagine a defence lawyer would have in these proceedings?
The defence lawyer has the role of challenging the evidence, and I'll come back to exactly his point in about another 3 or 4 minutes. The Justice and Security Bill is, in the words of Lord David Pannick, leading barrister, indeed the government's leading barrister of choice, unnecessary, unfair and unbalanced. Now, he said unnecessary because we already have the public interest immunity system.
Would my honourable friend give way?
I will, of course, yeah.
He's chosen to quote Lord Pannick. He will be aware that Lord Pannick, in the debate in the House of Lords on the 11th of July, also said, "I recognise that there may well be a need in some exceptional cases for a closed material procedure, although this should be last rather than a first resort." Not exactly.
In the course of the debate, it depends. Much of the response to this depends on how the government decides to respond to the proposals that the Lords have put, or the amendments to the Lords have put. Well, if you'll forgive me, I now run out of injury time. So, if a case involves sensitive information, the Secretary of State asks the judge's permission to keep those documents away from the court. The judge examines the evidence and makes a decision which balances national security with the interests of justice. Now, evidence can be shown in the PII system in an edited form. Witnesses can speak from behind screens, whether they're spies or special forces or whoever else. Suspects can be given the gist of the case against them. The court can sit in open or in camera. All of these operations are possible under the PII system now. And the PII system has served British justice well for decades, not just against the threat of terrorism, but against the Soviet threat, which in many ways was much more professional, against the previous Irish terrorist threat. The proof of this, no government, including this one, can point to a single court judgment which has undermined national security. Not one. And this is not, I will, because it's him. Yeah.
I'm very grateful to the right honourable gentleman. I mean, he's right to say that no one can point to PII leading to a disclosure of evidence, because the whole point about PII is that it excludes evidence.
It's the last word.
The whole point about PII is that it excludes evidence. So by definition, there's going to be no compromise of national security with a PII, but there can be no evidence before a court either.
It actually balances the demands of national security and of justice. That's exactly what it does. And to pursue this point, I don't want to distract too long from this, but I discussed this at some length with Pannick, as my right honourable friend referred to, with a number of lawyers who operate in this system all the time, not just as an aside or even as a criminal lawyer, but all the time, and indeed to the special advocates. And this is not just the view, as I say, of some civil liberties extremists, as my right honourable friend, the member for Rushworth, tries to imply. It's the view of the Joint Committee on Human Rights, which is unpersuaded, that was the words they used, that the existing law is not up to the task. It's the view of almost all the special advocates, the lawyers who make closed material procedures work now, and who understand it better than anyone else. Indeed, I would argue they are actually the only people who understand both the strengths and weaknesses of the procedure they operate. It's a view of Lord Pannick, as I said. It's a view of the former Director of Public Prosecutions, Lord MacDonald, who had a formidable record of prosecution against terrorist cases, or in terrorist cases, in his time as DPP. The government, of course, and the security agencies and their proxies say the opposite. Just as they did, in fact we had the reference earlier, just as they did when it was proposed to have the 7/7 inquest. What did MI5 say? They said holding that in public would amount to handing over the keys to their headquarters. They said if evidence was not heard in secret, then it might have to release information from top secret intelligence files. No such thing happened. Instead, we learned a great deal about what happened at 7/7. We learned about failings in operations, in data handling and management, all perfectly proper things for the British public to know. All perfectly proper things for the British public to know. And not a single failure of security or intelligence. As was said by the honourable gentleman, Dame Justice Hallett ran it very well indeed, as we expect our security experienced judges to do. They managed that balance nearly perfectly. So there's no doubt that this sort of information is far more likely to come out. Important information about the scrutiny of the state operation is far more likely to come out in an open court of law than by any other means. And I even include that, the ISC. Good job though it does, even more important than that. Now, many of the government misdemeanours I've just mentioned have been and gone. Inquests held, claims settled. But the problem of governments using the rhetoric of national security as a shield for politically embarrassing information has not gone away. In recent years, we've seen allegations of government complicity in torture and extraordinary rendition. We've seen seizing Gaddafi's political opponents, handing them back to the Libyan dictator to face imprisonment and torture, the case that was settled last week. And the use of drones now. The future, I suspect, will be about the use of drones, and which have killed scores of innocent people, and we will be involved because of our intelligence, I suspect. So this issue is still very current indeed, the issue of exposure of state misdemeanour in the courts. Now, it's worth looking at an example to see how the state actually currently uses closed material procedure when it's able. And as luck would have it, we have an exactly topical case right now in the case of Shurda Mohammed. 2 weeks ago, a British court heard allegations the suspected Taliban terrorist captured by UK forces was tortured by Afghan security services. The secret document was presented to the court in redacted form, the way it would have been in closed material procedure. Indeed, it's actually that document was in the case that my right honourable friend referred to, the Mayor Evans case, at an earlier stage. But the court did not allow the redaction of the secret UK eyes-only document. So we now have both the redacted and the unredacted copies in the public domain. And so we can see what was redacted, supposedly, for security reasons. Paragraph 20 of it talks about a visit to this particular prisoner by British Embassy staff and Royal Military Police. And it reads as follows, just one section of it reads, the detainee showed the visit party some of the injuries which he claimed were made as a result of being beaten several times with steel rods to the areas of his legs and feet, which he claims left him unable to stand afterwards. Photographs of some of the alleged injuries were also annexed. Now, where the security interest of the British state is in redacting that, I do not know. But it's absolutely material to the case that was in front of the court on Shurda Mohammed. The information poses no threat to any agents, no threat to any techniques, no threat to any British national interest, and yet that was one of the redactions. The only negative effect of showing it in court, of course, was the possible political embarrassment that we may not have met our duties under international law and under the rules of war in protecting a prisoner who was technically under our command. Yet this is exactly the sort of public interest information which will be concealed in the future if this bill, or could be concealed in the future, if this bill became law. Now, with closed material procedures enshrined in law, the agencies would be tempted, it would be inevitable, it's human, to protest that any information relating to activities was sensitive. We've seen it before. We saw it in the Binyam Mohammed case. More cases will be heard in secret, no defence lawyers, victims, press or public present to challenge or report what transpired. Now, evidence heard in secret cannot be easily challenged. I think we need to address this straight off. Inconsistencies cannot be spotted. Witnesses cannot be properly cross-examined. Under these conditions, evidence may not be worth the paper it's written on. Now, let me give the House another example of how this system can fail. There was a control order case a few years ago, it was under the previous government, where the suspect was accused of entering Britain at a specific date and time using a false passport. And the passport was part of the evidence. Shortly afterwards, exactly the same evidence, including the same fake passport, was used against a different suspect in another totally unrelated case. They were both supposed to have used the same passport on the same day, and of course that was clearly not possible. It was only by lucky coincidence that the same one of the roughly 70 special advocates there are, the same one was handling each case. He recognised the evidence and was able to point out that this was simply false. Now, I don't believe it was an intentional misleading of the court by the agencies. I think it was simply a mistake. I think it's simply a mistake, but it's a matter of public record, and the special advocate concerned is actually now a judge. It demonstrates very easily how the CMP procedure can fail miserably over critical issues of justice. That's actually why the Supreme Court Justice Lord Kerr, former Governor Prosecutor in Northern Ireland during the Troubles, subsequent Lord Chief Justice of Northern Ireland, said the following: "It would be, at a stroke, the deliberate forfeiture of a fundamental right which has been established for more than 3 centuries. The Justice and Security Bill is being sold as a fair way to protect our national security and justice. It does."
Hazel Blairs.
Thank you, Mr Deputy Speaker. It's a pleasure to follow the Honourable Member for Halton Price and Howden. I'm not entirely sure that we'll see completely eye to